This is Talkin to America. I'm your host, Aaron Zellman. Our guests today are Elo Jones and Don Doig of the Fully Informed Jury Association. Today we'll be talking about how you can stay free when you go to court. Well, let's start with Don. What is the purpose of a trial by jury in the traditional and constitutional American legal system?
Traditionally, trial by jury had a political purpose beyond the simple purpose of finding the facts in a case. Did someone commit a crime or not? Beyond that, and the reason why trial by jury is so important, I mean, why not just have a judge decide the facts of the case? Juries are traditionally the conscience of the community. Their purpose is to make sure that the application of the law is consistent with community values, and traditionally it evolved that the purpose of trial by jury is to actually ensure that the rights of the people are protected against prosecutions by the government in cases where there might be a question about the justice of the law, the constitutionality of the law, the fairness of the prosecution. All of that is a proper function of the jury to decide, and in that process to ensure that the system does not begin to systematically violate the rights of citizens. What it comes down to is that the jury traditionally, and for hundreds of years, and we get into the history of this, but for hundreds of years, the jury has had the power, and we maintain the right, to say not guilty if they believe a law is unjust or unconstitutional or misapplied, even if the law is technically violated.
Well, Don, I understand there's some history behind this. There's been some famous trials, and maybe you'd like to elaborate on some of those.
Sure. Well, arguably this power goes way back to the Magna Carta in England, and our legal traditions are derived from the English common law tradition, and it goes clear back to the Magna Carta. And one of the really important early cases was the trial of William Penn and William Meade, who were Quakers, Quaker preachers in London, and this is before William Penn moved to America and founded Pennsylvania. Back then, it was illegal to preach or to practice an unapproved religion. The only approved religion was the Church of England, the Anglican Church. Quakers were not considered a legitimate religion, and it was against the law to preach it. So the authorities closed down William Penn's church, and in defiance, they met in the street out in front of the church and held their service. William Penn and William Meade were arrested and put in the Tower of London. They were possibly facing death for violating this, really what we would say is really a bad law. And the jury, under pressure, the judge told the jury, look, there's no disputing the facts of this case. They did what they're accused of doing, and that's against the law, and you have no choice but to convict. And the jury said, nope, we're not going to do that. So the judge locked him in the jury room for several days without food or water or toilet facilities, and still refused to convict, and so they were fined, and those that refused to pay the fine were actually thrown in the Tower of London for several months until the High Court of England threw out the case and affirmed that jurors have the right to vote their conscience, and they are not rubber stamps for the government, and the government cannot punish them for a verdict that the judge or the government thinks is an inappropriate verdict.
Some others, Aaron, following the Magna Carta and William Penn, John Peter Zinger, who was a German immigrant, the jury refused to find him guilty of libel for publishing articles in his paper critical of a king-appointed political figure. And then in the Whiskey Rebellion, when they took the Whiskey Rebellion resistors, the tax resistors, to trial, the jury refused to convict a single one of them, and they actually had to repeal the whiskey tax. Before that, in the Salem witch trials, they finally ended when juries consistently refused to find any of the accused guilty. And we all know about the Fugitive Slave Act, which could not be enforced in certain states because the juries refused to enforce it. Prohibition. Juries refused to enforce prohibition laws. So this has been a long tradition of political control by the people who do in fact own the government. It has been a feedback to our government. It is a check and balance on government, and it is an ultimate veto power against bad laws passed by the legislature.
And in the case of the Zinger trial, that was actually, along with the William Penn trial, considered to be important precedents when it came time to write the Bill of Rights. So these verdicts by juries ended up becoming part of our legal foundation in America.
Well, Elo, I have a question for you along these lines. If trial by jury is in the Bill of Rights, does that imply it has a political role?
Yes, and we were just talking about that a little bit, of course. And the political role of trial by jury, first of all, juries are, as Don was talking about earlier, juries are constituted to protect private sovereign citizens from government tyranny, and they can do that by refusing to convict no matter what the charge, no matter what the law, no matter what the evidence or the facts in the case. Juries can simply refuse to convict. Trial by jury is, of course, mentioned in the Bill of Rights 3 times and in the Constitution itself 1 more time. So it's set forth as having this political role as a check and balance on government 4 times in our Constitution. Now, why is it there? Well, as we know, and we see this sometimes, of course, in concealed carry and weapon carry cases, we have the right to self-defense. We have the right to life, and you do not have the right to life unless you can exercise your right to defend that life. Jurors simply refuse to convict people who are trying to defend their life or the lives of their family, and in doing so, they can circumvent all of the government employees, all of the people who work for the government, who are part of the political structure of government, by vetoing the actions of the government. And unfortunately, it still, of course, harms the people who are charged and being persecuted by government because they have to pay for an attorney sometimes. They sometimes lose their jobs. We had a case we worked on of a fellow driving through Ohio with weapons, which he had legally, of course, as you would have to under the Second Amendment, but he didn't have legal permission in Ohio, and so they arrested him, and they trashed his vehicle and confiscated a lot of his property, including his computer, which he needed for work. And he didn't get a jury trial. We hoped he would get a jury trial because we were educating all the people in that area so that they could step in and exercise their political role of serving as a check and balance on government. And we continue to do that. That's what the jury is for, to protect citizens against government action that is unfair. Juries, of course, also can protect society from truly dangerous people who are really criminals, where there's a victim or those people are violent or need to be locked away and kept to keep society safe. But mostly juries are there to protect innocent people or people who have not done anything that is actually a crime, where there's no victim, and that way act as a political check on our government and our legislature's creation of unreasonable laws.
Well, let me jump into a question here that I'm sure a lot of people are thinking about at this moment is, what is the legal doctrine of jury nullification?
That's actually the name of the legal doctrine. It's jury nullification. And it is that jurors have the power to vote their conscience and to acquit if they believe that justice requires it, if they believe the law is wrong or unjust or unconstitutional. That's not to say that they have the power to bring a conviction beyond what has been charged by the prosecutor, and it does not mean that the actions of the jury have any precedent in terms of changing the law or anything like that. It's that in this particular case that is being heard by this particular jury, they can say not guilty and let that particular defendant go free.